Rosin. I'm a teacher of English at Radnor High School just outside Philadelphia. And I'm here today with Marissa Bluestine, who has a lot of experience in working with the situation that we've been discussing today, which is ineffective counsel. Marissa, why don't you give us a little bit of your background?
Sure. Hi, everyone. My name is Marissa. I currently am at the Quattrone Center for the Fair Administration of Justice, which is at Penn Law. Before that, I ran the Pennsylvania Innocence Project for 10 years, where I represented people who had been convicted of crimes they did not commit. Sometimes a factor in those cases was that their trial lawyer was ineffective in representing them. And before that, I was a public defender in Philadelphia for about 10 years. And while I don't know of any cases on which I was ineffective, it is quite possible that there were some. But it's an issue that I've been pretty well versed in for a while now.
All right, let's get rolling here. I want to start a little bit with context. I mean, you know that on TV and in the movies, we often see brilliant lawyering. Sometimes it's successful, sometimes it's not. Students are probably familiar with To Kill a Mockingbird, and maybe have seen movies like My Cousin Vinny, things like that. There are plenty of other examples of lawyering that doesn't work out, possibly because of ineffectiveness, possibly because it's an effective lawyer and it just doesn't work. And we're going to try to cover those cases today. So a lot of this seems to start with the Sixth Amendment. And so I was thinking that I'd read the Sixth Amendment and ask you to comment on where some of this comes from. So
sure.
Let's see here. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So that last phrase, the assistance of counsel for his defense, it doesn't say anything about the quality of the counsel. Where did challenges to ineffective counsel come into the law?
So it's been quite a while. I mean, remember what you just read, though, Carl, has a lot of different rights that are in there, right? There's the right to a speedy trial. There's a right to have witnesses. There's a right to confront witnesses, a right to subpoena, and then comes assistance of counsel. But you're right. It doesn't say effective assistance of counsel or even competent assistance of counsel. And I think it's important to remember that the states, the now 50 states, it wasn't a requirement that they follow that amendment until about starting in the 1920s, and then going up through the 1960s through the Gideon versus Wainwright decision, which is a pretty famous opinion, which we can kind of get to. So the first question then that the courts had to deal with was, when we say assistance of counsel, who do we really mean by that? And the first question was that, and the states generally had statutes which required counsel to be appointed if somebody was facing the death penalty. And the death penalty then could have been for rape, it could have been for murder, could have been for a lot of different types of crimes. But most states only required counsel in death penalty cases. And so you started to see some challenges to, okay, if I have the right to counsel, it must mean I have the right to somebody who knows what they're doing, or at least is not going to mess it up. So then you started to see the courts kind of grappling with that question. Because you can have the right, but for it to mean something, it has to mean that you have the right to a truly effective counsel, or somebody who can actually represent somebody and do the job. But you had all over the country, people were charged with crimes, serious crimes, and they would go in front of a judge and say, I want a lawyer. And the judge would say, so sorry, Ms. Bluestine, you're not charged with a capital offense, so we don't have to give you a lawyer. And that's exactly what happened to Mr. Gideon. And when he stood up in court in Florida and said, I need a lawyer, and the court says, you don't really get one. And he said, but the Sixth Amendment says so. And the judge said, sorry, we can't do that for you. So he was forced to represent himself. And that's the case that wound up changing the law for everyone. So those two issues, do I get a lawyer and how good a lawyer do I get, kind of developed together. almost side by side as they went through the court systems.
And you're talking Gideon versus Wainwright, you're talking early 1960s, correct?
It's just past its 50th anniversary, right?
That's very recent. And I think people think of it as just sort of this basic thing. But
Yeah.
well, let's get into some specifics. You have dealt with many cases where you, at least in the appeal side, have been following on cases where you have, in your research, discovered the initial conviction resulted, at least in part, from ineffective lawyering. Can you give us a couple of examples? We had talked briefly about these, and I would especially like to hear about Dante Rollins and Sean Thomas. So let's start with Dante Rollins. Can you tell me a little bit about that?
Sure. So Dante Rollins' case was one of those that, and Sean's too, but really with Dante's, if I had had that case as a public defender, I truly believe that case would not have gone to trial at all. So Dante was accused of and convicted of taking part in a shooting that happened in an area of Philadelphia known as Strawberry Mansion. It's a neighborhood. And he actually was identified on the scene by the grandmother of the child who was shot. The people were aiming for somebody else and the child was hit kind of in the crossfire, unfortunately. The grandmother looked at the shooters and thought she saw Dante. Right? And she said, Dante's shooting at us. The problem is at that moment, Dante was about 12 miles away with a group of 4 friends of his shopping. How do I know that? Because we found video of him from the stores on their surveillance cameras at the exact same time as the shooting. And not just Dante, but the 4 friends who were with him are also on these tapes. Those tapes were gotten by Dante's mother. After Dante was arrested, Dante's mother went down to the stores the next day and with security guards sat down and went through the videos until she saw Dante and then asked them to pull those tapes. They pulled those tapes. So she had them. She knew exactly where they came from. She met with Dante's lawyer very soon after they hired him. He was not an appointed lawyer. He was hired by the family. She gave the tapes to him and thinking it would all be over. It wasn't. They get to trial, and those videos were never even played for the jury. Not one of them.
So here's the question that everybody is probably asking right now. Why in the world were they not included?
It's easy. I don't have an answer for part of that. So when we got the case, we had to show the judge, and because this is what happens at trial. If you are alleging that the trial counsel was ineffective, you have to show what they should have done instead. So we played the videos, and we brought to court 3 of the 4 men who were with Dante, who would have testified. He was with me. He was shopping. The 4th one, unfortunately, had died before we got to those hearings. And I asked the lawyer, I put the lawyer on the stand, and I asked him that question. Why didn't you put this evidence out? And honestly, his answer to me was very chilling, because what he said was, look, there were gang overtones in this case. I didn't want to put 4 young men on the stand. And honestly, what he really meant by that was he didn't want to put 4 Black young men on the stand. And that was clear to everybody in the courtroom what he meant. And that I found appalling, not just because those are the people who was with Dante. I mean, who else would he be with but his friends? But they were on video. So even if he thought there might be some issue of putting them on the stand, there was objective proof that what they were saying was true. So to me, the frank out racism involved in that was just horrible and cost Dante 10 years of his life in prison.
And you're saying that's the lawyer's racism?
Yes.
Yeah. You said something that I think is interesting that I would love to ask you about a little bit more. You said what they should have done. There's a kind of what he could have done and what he should have done.
Right.
And we know it's difficult to, you can always come across a different way. Oh, the initial defense didn't work. Should have tried something else. Can you talk a little bit about the difference between what someone could have done and what someone should have done?
Yeah, and that's an important distinction, Because what the courts say is you're entitled to effective counsel. You're not entitled to the best lawyer out there, right? If you are a lawyer, Carl, I'm not entitled to have you as my lawyer. I'm just entitled to have someone who can get me through the day. So the courts have to kind of look at that, and they have to say, okay, there's what they did and what they should have done. And so what they try to use as an objective standard. What would a reasonably competent lawyer have done under these circumstances? Would a reasonably competent lawyer have put the videos on evidence for the court, for the jury to see? Would a reasonably competent lawyer have called those witnesses to the stand? And the answer there is yes, like without a doubt, yes. So but it's really a lot of questions at once. It's what would a reasonably competent lawyer have done? And it's if the trial lawyer had done that, would it have changed the outcome? So it's not just enough to show that the lawyer could have done more or should have done more. You have to prove that the outcome would have been different if the lawyer had done what you suggest he should have. And that's how judges, so you're kind of looking back through time to try to say, okay, is what the lawyer did reasonable? And if it's not, and he did this other thing, would it have mattered? Only if you get through both of those are you talking about a case that should be overturned. And that's exactly what happened in Dante's case. We showed a reasonable lawyer would have at least shown the videos and called the witnesses. And yes, it would have affected the outcome. And that's why that was able to.
Great. Let's talk about Sean's case, which I know is one of the big successes of the Innocence Project when you were in charge there. You tell us a little about that story and how counsel figured into that scenario.
So that's another head scratcher. And when I told my brother about this case, he thought I was lying, that I was making it up. I was not telling the truth. But Sean was convicted of a murder that happened. Like I said, Dante was shopping. Sean's alibi was even better. He was standing in front of a judge at a hearing when the murder happened about 10 to 12 miles away. I mean, he was 17 at the time. He'd been arrested the night before for trying to steal a motorcycle, and he was held by the Philadelphia police overnight and then brought to the courtroom the next morning. So he was in police custody the entire time, from when the murder was planned to when it was carried out to when they were divvying up the goods supposedly at the homes. So his alibi wasn't friends. It was the Commonwealth of Pennsylvania. So, and it was literally at the exact same time as the murder. But Sean got arrested 2 years after that. Now, the records were kept in juvenile. And doesn't know, juvenile records are kept separate from adult records. They're supposed to be kept forever, and they're kept under seal. But the lawyer could have gotten those records to show that Sean was actually in custody when that murder happened, but he chose not to do that. The only thing he put in front of the jury was that he signed a subpoena, that he put on somebody to say, yes, we have the subpoena that was signed on that day by Sean. So they had him in court at some time during the day, but not at 10:05. And the jury was like, well, maybe he went and committed the murder and then he went back to court, which is a little bit odd. So that's how he gets convicted. But I will tell you that fact, the fact that the lawyer didn't produce the entire alibi at trial, actually wasn't even part of the exoneration. The exoneration was on entirely different grounds, which was that the police actually withheld information that would have led them in a different direction. But I think that ineffectiveness plays pretty high, because I think it's kind of hard to get somebody convicted when it's the Commonwealth of Pennsylvania. That's your alibi witness.
So I want to talk a little about that withholding of information. Very often, a lawyer might have access to the important information and fail to use it, like in Dante's case. I know that it's now the law that certain potentially exonerative information, I'm not quite sure what the word is, that has to be shared. Can you talk a little about the rules that make it so that lawyers, whether they're good lawyers or bad lawyers, actually have access to everything they need?
Right. I mean, you can have the best lawyer available, and if they're not giving all the information, that trial's not going to come out the way it should, which is why the rule is that prosecutors have to turn over information which is exonerative, as you said, which is in exonerating means either that it points to somebody else who did the crime, or it impacts a witness's credibility, like that they're getting a deal for testifying, or they're being paid for testifying. That has to be told to the jury so they can determine whether that witness is credible or not. Right? And so if that information is in the hands of the state and they improperly don't hand it over, then there's really not a lot the defense lawyer can do because they don't know about it. They can't use it. In Dante's case, that information, the videos, could have been in either the state or the defense's hands. The state could have investigated to see, heard about the alibi and gone to investigate and pulled the tapes themselves, or the defense could have done that. And in this case, it was the defense did that, and they had it, and they may or may not have provided it to the state. So that information can come up on either side. It's very different in the civil world. So in a civil context, if one person is suing another because your tree fell on my house, and together we develop the information, both sides. That's not what happens in criminal. It's really all pretty much on the state, and then they're supposed to share the information with defense counsel, but sometimes there's a mistake.
Is this what I'm thinking of, like TV shows, they often talk about discovery. Is this what you mean by discovery?
That's exactly what we mean. Although my honest opinion is using the word discovery is not proper in criminal because it's not the same as what happens in civil. It's more like a game of go fish, right? I mean, you say to me, do you have any witness statements? I'm like, sure, here you go. Or you might say, do you have any forensic results? And I say, okay, you can have these. But I don't have to hand over everything that's in my hand. And that's what's very frustrating.
You had mentioned that the right to counsel came out of a legal ruling in Gideon versus Wainwright. Was there a court case that determined this?
Yeah, there was a series of them. The most famous is one called Brady versus Maryland. And that case actually wasn't even an innocence case. It was a case of somebody who was involved in a murder. They actually committed the murder, but there was information that the state didn't hand over to the defense lawyer when they went to sentencing, and that would have impacted him getting the death penalty. So there, the lawyer did their job. They did a very good job, but they couldn't do it all the way because they didn't have all the information they should have had. So that's not an ineffectiveness case. That's a case of prosecutorial misconduct. Gotcha. But sometimes it's hard to tell the difference between the two.
Sure. Another question before we move on. You went back and you were talking about Sean's case where he was standing in front of the juvenile master. I think we can all imagine there are cases where there are reluctant witnesses. One would certainly assume that a juvenile justice for the state would feel the obligation, I have to report this or I have to appear. What are the circumstances in which someone has to be or can be compelled to appear in court and bear witness?
That's that other part of the Sixth Amendment, right? So in addition to having the right to confront witnesses, you have the right to call witnesses. So that's when a subpoena gets put out. And a subpoena is a court order. It's saying Judge Rosin is requiring you to be in court on this day at this time. And you can ignore it, but if you do, then Judge Rosin can send the police to get you, and you can be arrested for failing to observe the subpoena. So an estate actor is no different. I can serve a subpoena on anybody I want to if I think they're important to my client. I could serve it on the governor. I could serve it on the president. They can then come into court and say, I buy this because I actually don't know anything about this case, or I have nothing to do with it. That's called moving to quash a subpoena, and they can do that. They do that all the time. But if that's not done, they have to obey the subpoena and they have to be in court, or there are consequences. And the defense has that right just as much as the state does.
Great. One thing that we've kind of alluded to and mentioned very casually along the conversation so far that I want you to dig into a little more is this term appeal. Tell me about the concept of an appeal, because I know for the Innocence Project, you're not trying the initial cases. You're mainly focusing on appeals after someone has been convicted, wrongful convictions for whatever reason. Can you walk us through the concept of appeal, how that works?
Yeah, and this is why ineffectiveness cases take so long to resolve. If the issue really was that the lawyer is ineffective, it takes a long time, because that issue, whether your lawyer did a proper job or not, is not something that you can really address on an appeal. So there's an appeal, which is going from the trial court to the next appellate court to kind of say, okay, what happened at my trial wasn't good. But you have to be able to point at the transcript and to say, here's where the court erred. That my lawyer made an objection, the judge didn't agree with it, and they made the wrong ruling. Or I wasn't able to get this particular juror seated, or the prosecutor made this bad argument. It literally has to appear in the transcript. That's called a direct appeal. So questions like my lawyer should have, you can't really point at the transcript and say this is where it happened, because you don't have that evidence. So those are direct appeals. Those second appeals, we call them collateral appeals. Most states call it a habeas corpus petition or something like that. That's where you can raise those ineffectiveness claims. My lawyer should have called this witness, or my lawyer should have done this strategy. That's in the second appeal called a post-conviction appeal or collateral appeal or habeas appeal. And so you've gone through the first one, that takes years. And then it's the second appeal that you're trying to raise those issues on. That's why it takes so long. In Dante's case, we raised those issues on a first collateral appeal called a post-conviction appeal. And that's where we were able to get relief. But it still took 10 years for him having served that sentence before he was released.
And how many appeals did it take to get Sean free?
I can't even count that high. Sean filed his own appeals for years. He must have filed 5 or 6 on his own.
And 27 in prison, yes.
He was about 26 years in prison, right? 26 years in prison. And he did a lot of those on his own, and the courts just dismissed them, didn't give him a lawyer, didn't give him help. And then when we got involved, we were able to develop evidence to get him into court that led to his exoneration, but that took a long time. That took 9 years just from us.
Oh. I've got one more question that, it is good that although it took a long time, Dante became free and Sean became free. But
right.
One of the things that we had talked about earlier is that sometimes even an ineffective lawyer is not ineffective enough for the courts to find a constitutional violation. Do you have some stories that you can share with us? And I'm guessing these are not going to be as happy stories, but examples of ineffective lawyering that didn't rise to the level of actually creating a constitutional violation.
Right. And that's where that issue of, you can be not competent, but does it affect the outcome? That's how it comes into play. So there are lots of examples of lawyers being drunk during a trial, like visibly drunk and intoxicated during a trial, sleeping during a trial, like head down on the desk, sleeping during a trial. And those lawyers were found not to be ineffective to the point that the Constitution was impacted. So they were found to be ineffective because you really shouldn't fall asleep during trial. But because it happened during a phase of the trial that wasn't that important, the court said, well, it wouldn't have affected the outcome. So we're not going to overturn that conviction. You have to meet both of those prongs to be able to meet that constitutional burden. Although I would kind of argue if your lawyer is sleeping at the table, the effect that has on the jury is probably pretty profound. That if the lawyer's not taken it seriously, why should the jury? So if I were on that court, I think I would have made a different decision. But that's the way the courts have traditionally held that. If that happens during a time in the trial that's not all that important, it's not going to be found ineffective. And it's going to stand.
Hey, a last question that I want to make sure that we talk about is that, even a competent lawyer, even a good lawyer, can do a bad job of representing a client or make a mistake that causes counsel to be effectively ineffective or practically ineffective. And there are a lot of reasons that could happen. One thing that I think that it would be interesting to hear about is strategy. A lawyer has to plan the arc of testimony. I'm going to do A and then I'm going to do B and I'm going to draw something out so the jury can see it. Can you talk a little about planning and strategy and the ways in which lawyering may end up appearing incompetent because it didn't work, but or maybe it actually could work. But let's talk a little about strategy, and I think that's probably where we can wrap up for today.
Sure. Yeah, I mean, there are certain decisions that are up to a criminal defendant. There are, I think, 3 of them. First is whether or not to plead guilty. The second is whether to testify or not. And the third is whether or not to seek an insanity plea. So other than those 3 decisions, everything else is up to the trial lawyer. So the strategy, whether to call witnesses, what witnesses to call, how to cross-examine, whether to open, whether or not, all of those are part of the strategy that the defense lawyer is in charge of. And that while the defendant may have some input, it's the lawyer's call. So if the defendant has an alibi, like Dante did, it's up to the lawyer to actually call those witnesses to the stand and have them testify in front of the jury. And no one else can make that decision. It's just the lawyer's decision. And there may be times when, so for example, I know of a case where somebody was convicted of a crime that he says he had an alibi for, and they went to trial. And the lawyer representing him is probably one of the best lawyers in Philadelphia, a terrific trial lawyer, and did a great job on this case. They go to trial. They make opening statements, so they both say what's going to happen to the jury. The prosecutor goes first, then the defense lawyer goes first. And the defense lawyer says something like, my client wasn't even there. So you're going to see he wasn't even there. And the prosecutor put on his evidence, and the defense lawyer did a terrific job cross-examining the witnesses to the point where, honestly, it wasn't clear what they would said. But he had raised so many issues on the cross-examination of the witnesses that by the time they got to the mid-trial, the lawyer thought it was over. He thought that he had raised enough doubt that they didn't have to put on any evidence. And under the Constitution, under the Fifth Amendment, a criminal defendant can just say nothing. They don't have to do anything. They can just sit there the entire trial, let the state put on all their evidence, and then just see what the jury does. So the lawyer thought, based on how the case, as we say, went in, that he had it won. So he didn't put on the alibi witnesses. He didn't put on any evidence, and argued to the jury that they didn't meet their burden, that they didn't show that he did this or that he was the person who did this, and he let it go to the jury. The jury convicted based on that. And so it came back on an ineffectiveness claim to say that he should have put on the alibi witnesses. And I have to say, I don't think I would have made a different decision. Not that I'm the world's greatest lawyer, but I think I'm competent. And I probably would have made the same decision, because putting on witnesses means risk. It means that the jury may not like them, or the prosecutor may cross-examine them too much, or they may not testify the way you think they do. So why take the risk if you think you have it won? Because beyond a reasonable doubt is the standard that we require. It's a very high burden. So you could have a terrific lawyer make a decision which makes a lot of sense at the time, and only looking back on it do you kind of question it. And that's why we have that double standard. It's not just enough to say that they should have done something different, but would it have changed the outcome? And in this case, it's that first question. Should he have done something different? Probably not. Given the way the case went out, it looked like a good strategy at the time. But all that is up to the lawyer to make that decision.
Marissa, thank you very much. And you are certainly, beyond a reasonable doubt, an excellent lawyer. And it's been a pleasure to talk to you about this. Thank you again for your
Carl,
time today.
Thanks so much for spending the time with me. Always nice to have you.